Moving forward, we have with us Mr. Aditya Mathur. Sir is the founding member at Mediate Guru and a legal dispute resolution council. He specializes in the matters related to the corporate and commercial disputes, intellectual property law, and has represented his clients in arbitration before Supreme Court of India, various high courts, and quasi-judicial authorities. Mr. Aditya regularly represents some of the leading multinational companies, including but not limited to Hero Motocorp, Kohler India, Daikin, Firefox Bikes, Calvin Klein, Shaktiborg Foods, and many more for resolution for commercial disputes and advises on pre litigation strategy. Mr. Mathur also regularly advises some leading crypto and NFT platforms in India regarding their new service launch legality, FDI policy permissibility, and in developing regulatory risk mitigation strategy. In addition to this role, as a dispute resolution counsel, Sir is a driving force behind ADR Broadcast, an influential online ADR platform. In plus to his professional roles, Mr. Aditya is sought after speaker and respected judge in competitions related to the ADR things. Imbibing all this, Sir is surely a firm advocate for future of ADR, and we are highly obliged to have him with us today. We welcome you, sir, and I request you to please come forward and motivate our audience.
Good afternoon now. Thank you so much for having me. So one of the drawbacks of being the last speaker is that all the good things have already been told by my eminent speakers. I would just like to add to what they have already told. And one thing I really believe, and as a lawyer that just graduated a few years ago, trust me, negotiation is the key that will take you forward as an advocate in the coming forward. Training yourselves in ADR techniques will not only help you in conducting matters related to mediation arbitration exclusively, but also in your traditional litigation practices in whichever way you want to venture into. And I can tell this by my personal experience also. I tell you a small matter that I just finished up a few days ago. So I deal with Google a lot. So Google is one of our clients. So in their platform YouTube, many infringing videos are uploaded on the YouTube platform. So for example, Amul Milk, a person, influencer who makes video on these, giving his reviews on milk and everything, will make a video about Amul milk, that this milk is very thin and it's made of impurities and this is not good and so on. So what Amul does is, Amul sues this influencer guy that, sir, how could you make a derogatory remark against our products? You don't have any facts to back up your allegations and make up a case of a defamation against him. So he has a defamation case against him. Now, what usually happens in this matter is, before an adjudication by the court is done, these Amul and this influencer guy goes for a mediation. What happens in this mediation is, Amul set his terms that, sir, please take down this video from YouTube, pay us this amount for your derogatory remarks, the losses that we incurred because of remarks, so many views, 1 million, 2 million views that you have, please pay us a certain amount, take down this video, and from later on, please don't upload such video against our company policy and so on. The influencer sometimes agrees to that, sometimes he does not. He says that the facts that I claim is true and so on, or the matter goes on. But if an agreement is made at that point, please see how constructive that matter has become constructively over at the mediation stage only, and it has saved so many years, so much cost of both the litigants in this matter. And this is just a day's matter that I'm telling about. There are hundreds of matter of these corporations that go on throughout the Delhi High Courts and the district courts in India that I've noticed. So, like, as you all know, if you've read the Commercial Courts Act, before filing of any commercial matter, and any matter that is above 3 lakhs of valuation in India, a pre-litigation mediation is mandatory. So the parties have to go mandatorily to the mediation first, then only they can go to the court. So that is a provision in the Commercial Court Act. Sir, please first of all go to mediation. If there is a non-starter in mediation, or you have not settled, disputes that cannot be settled in mediation, then only come to the court. So courts in India are also very proactively encouraging mediation. And so as young advocates and upcoming advocates, very important that we right now gear ourselves for this mediation function, and we learn the skill of negotiation at this stage. Right. Moving on to the topic of this seminar, restorative justice and mediation laws. So this is actually a very interesting topic that has come to us, restorative justice and mediation laws. So mediation per se is a result. Two parties set into mediation to come to an agreement, and restorative justice is a byproduct of that mediation process. So restorative justice happens during that mediation, and it's not the end product. Restorative justice is the byproduct of that mediation happening between the parties, right? Restorative justice basically, so for restorative justice to happen, there should be first of all an compliance agreement from a party that a wrong has been done by me. So for example, let's take an example of a hit and run case. A bike was standing on a parking, cars came by and hit this guy. He fell down, he suffered injuries, and this car guy just ran away, right? So this is a very so the criminal case will be filed in the court. So now, if this matter is referred to mediation, what will happen is, first of all, to refer this to mediation and restorative justice to happen, this car guy that hit has to first of all satisfy. He has to satisfy himself, and he has to say that I have hit this car. This is my fault. I have hit this car. I completely take responsibility of it. I take the responsibility of this accident. It has to happen. Then only the parties can get into mediation, and restorative settlement can happen between the parties. So an important thing in normal mediation, a party will not say I'm at fault, you are not at fault. They are both here to come to an amicable settlement in which both of them will be beneficial. However, in restorative justice, important thing has to happen is that one party has to admit that yes, I am at fault. Okay, I have conducted fault. Now, please, you tell me what can you expect? What do you expect for me to do? And then his behavior, and then he'll say things like I'll not do this later afterwards also, and restorative and other processes happen then only. So that's a very stroke different between normal mediation and mediation in restorative justice. So restorative justice in India, I think, as in other foreign lands, is not so developed right now. We are still developing. We cannot think of mediating these heinous crimes like murder, rape, still in India. The crimes that can be adjudicated through this mediation is only petty offences like accidents, theft, or so on. Apart from civil matters. So I have a very interesting question that I would like to ask the other panelists, is that in these matters, many times we understand that the person who has committed the offense is ready to come to this mediation. And it's a question to all of you: why do you think that the person against whom this offense is committing, who is the victim, would like to come in this setting? What does he get? What is he getting out of it that he doesn't get out of filing a complaint or winning a suit? So, for example, a theft is conducted against a person. If a complaint is filed, the thief is identified, goods can be recovered from him. So what will he get out of that mediation setting that he'll not get out of the court or by filing a complaint? What do you think on that aspect? His time. That's correct. So I think both of them are very valid points, but I think the financial thing is more valid. In a mediation setting, apart from your inherent loss, you can also get an financial setting to our end. And other thing is that many times people have a peace of mind when they know that the other person is here and he is guilty of his offense, and he is ready not to he'll not repeat this, and he has a transformative journey going on. So these are various reasons because of which a victim might be participating in this. And let's see, I think it's a very interesting area that we all will explore. So apart from this, so I would like to say that please train yourself into mediation. And now the question arises: how do you train yourself to be negotiator or mediators at this stage in which you are? So right now, the options available to you are trainings, mediation or ADR trainings, internship, courses, or joining these webinars and seminars that happens a lot for free, also for paid also. They're happening all over here and there related to ADR. So these are 4 or 5 options that you have to, but you have to act right now. you cannot expect when you graduate you will train into ADR, then you will become an go for a training and then get empanelment. All of this can happen right now. You don't have to wait to graduate. I did my training in my fourth year only, got empaneled with various panels for mediation as well as arbitration. So this is the right time to act, and I think as soon as you act, you will be better braced for the future. So thank you so much. I'll end this.